Are you ready? Okay. Good morning, everyone. We're going to go ahead and get the meeting started. We have Senator Ellis is running a little bit late. She's going to be here. Senator Grew is in appropriations, and he's going to try to be back. And he actually requested that we might change HB 126 to the third instead of the second bill to look at. And I told him I thought we could do that today because I know he wants to be here and hear testimony on that bill. So with that, we'll go ahead and start with our first bill, which is House Bill 15, HB 15, County Authority to Dissolve Museum Boards Clarification. This was another one of those good bills the Joint Judiciary worked on, and we seem to be getting a lot of their bills. So they need to quit working so hard maybe next year. And no, we're happy to do them. So, and there's no one here from the Joint Judiciary, is there? But, oh, well, there is. Okay. I forgot. Representative Crago, yeah, he kind of does it all. So welcome and glad to have you. What can you tell us?
Chairwoman Schuler, members, committee, thank you for having me this morning. House Bill 15, which as you said was a Joint Judiciary topic. Last year, we passed a law regarding the dissolution of a lot of these boards. And to be honest with you, I think it was an oversight because we had talked about this last year when we were going through the bill and exempting out the museum boards. And then once the law passed, this is an attempt to make sure we're actually following up on what we said we were going to do, in which that's just exempting the museum boards from the statute. And and the main reason why is there was just a lot of concern about the assets of these boards. What happens to all of the exhibits that are, a lot of them are donations, some of those are loans. Where do those go if we just decide to dissolve the museum? And there's ways around that. You can set up a private type of museum outside of the county structure, but I think just to protect that and going forward, just to make it clear in the statute that we're not going to dissolve these under that particular statute. And I think the representative from the County Commissioners Association is here as well and may have a few words, but that's really the intent. Follow up, make it clear we're not applying this to county museum boards.
Questions for Representative Crago? I had just one, just curiosity more than anything else. Does every county have a county museum? Is that a curiosity, or do you know that?
Chairwoman Schuler, I actually don't know the answer to that, how many do or do not.
And do you know if any of them have tried to shut down and dissolve their boards?
They have not. I mean, we did hear testimony on that. There was no efforts to shut down. I think there was just a lot of fear within the counties that might happen. You know, if the commissioners get upset at the board, this statute would allow them to dissolve it. And so that was the main thing, because all of the other boards are a little bit different. They're not necessarily taking donations, and they don't hold private property as part of their, duty, so to speak. And so that was really the intent behind this amendment.
Okay. Well, I think you answered my question. I had a couple of folks in my neck of the woods that asked about this. Of course, they both work at the county library and had some concerns and just wondered where it came from. And so I appreciate that background. So, all right. Any other comments or questions, Representative? Okay. We'd love to hear from our famous or infamous Mr. Riemann. I'm sure you have a little bit more information on this. Help us out.
Good morning, Madam Chairwoman, members of the committee. I'm Jeremiah Riemann here on behalf of the County Commissioners Association. I'll add a little bit more context. This really is about a political compromise that was struck last year relative to this issue. As we moved it forward, there was concern that was expressed about the museum boards. And the House passed an amendment that removed, or was intended to remove, museum boards from the bill last year. Unfortunately, that amendment, when it was drafted and passed, didn't capture all of the language relative to museum boards, so it left this one reference. You might ask, why isn't this in a reviser's bill? I think it's, as I understand it, it's not in a reviser's bill because it still, in essence, gave commissioners the power to do this. It was beyond just a technical correction. And so this bill is before you to follow through on that political compromise. I'll admit, commissioners are interested in evaluating this issue further, but that's for another day. The deal was struck, and this bill needs to pass to clarify things in statute, and for that reason, we support it. With that, I'd answer any questions.
Questions for Mr. Reedman? No. I just, again, just out of curiosity, most of the county libraries, at least I can think of a couple in my area, 3 of them, I guess, they allow for private donations and that sort of thing, rather than, things that have maybe been donated through the county. So is that the real nexus for this, is to figure out what to do with those, private donations and those kinds of things if they were to dissolve? Is that really the nexus of it?
Yeah, Chairwoman Schuler, as we were going through the conversation last year, it really was, what do you do with the assets of these museums should a county pursue dissolution of one of these particular boards? And to be clear, you can set up a museum board in a couple of different fashions. We were really just targeting those boards by which the county commissioners actually establish them and appoint the members of those groups. We had drafted some language last year that would require the commissioners to consider what happens with those assets. That wasn't favorably considered entirely across the board. I will say that the Museum Association for Colorado and Wyoming has indicated that they're willing to work with us on this particular issue in the future, but that's a conversation for another day.
Other comments? Just one more for me, I guess. So let's just say, I'm going to give you a scenario that we've got a county museum where there's some issues, and maybe the board has, maybe some have moved away, or they've lost members or whatever, and they don't have enough maybe to even constitute a quorum. How would that work now? I mean, who would deal with that? Would that be just a private issue then, even though it's a county museum? How would they move forward, I guess, is what I'm asking.
Madam Chairwoman, I would assume that in that situation, because it's a county appointed board, or assuming it is one that falls under this structure, then the county commissioners would then identify somebody to fill that seat to ensure that the assets are cared for and protected.
The only reason I ask that is I'm on another board or two, and it seems like that there's some issues with those kinds of things happening. So I appreciate the information.
Absolutely.
Anything else? Any other comments? Okay, thank you so much for your testimony. Anyone in the room that would like to testify on HB 15? Welcome. Come on up and introduce yourself, sir.
Yes, sir, Madam Chairman, Bill Winnie, Sublette County. Very quickly, the essence of this bill is, what do you do when you have a board that's out of control? It wasn't so long ago, the Senate Corporations Committee was hearing a bill on small districts where embezzlement was occurring and going on for years, and trying to wrestle with that one. And so in my mind, this is kind of one of the out of control things. At any rate, that issue of what do you do with an out of control board, I think it's a good bill. Subject to your questions. Thank you.
Questions for Mr. Winnie? Okay, guess not. Thank you. Anyone else wants to testify today, this morning? Okay, anybody online that would like to testify on this bill? Okay. All right, with that, I guess, unless you have any comments, questions, what would you like to do with this bill? Okay, Senator Baldwin moved the bill, and second by Representative Jones. Senator Jones, good Lord, having a hard time this morning. Too many representatives in the room. So, anything at all that you have a heartburn with on page number 1? All of it? Page 2, this is a pretty short and sweet bill, so any amendments or anything that you'd like to add? No? Okay. Question's been called. Let's take a roll call vote on HB 15.
Good morning, Chairwoman. House Bill 15, Senator Baldwin.
Aye.
Senator Ellis. Aye. Senator Guru has voted aye. Senator Jones. And Chairman Schuler.
Aye.
We have 5 ayes.
Okay, that bill is passed. Anybody interested in taking that one on? Recruits?
Sure, I'll do it.
Okay, good. Because I know for you, it'd be kind of a short, sweet, kind of a get-together for you, so, compared to some of the bills you deal with, so. All right.
you.
I'm glad to see the good representative. I had a request from one of our senators to wait for the other bill that we were going to do second and put it last, so I didn't have a chance to give you a text or anything, but welcome, thanks for coming. We're going to take a look at, instead of 147, we're going to bump on up to, we're going to go to 147, yeah. This is House Bill 147, unlawful trespass signage taking wildlife. And we're excited to have Representative Provenza here, so welcome.
Good morning, Madam Chairwoman and committee. Thank you for hearing my bill this morning. This is House Bill 147, unlawful trespass signage taking of wildlife. Where this bill came from is really from personal experience and also from hearing from many hunters and anglers in my county and across the state that have run into private property signs where it is clearly public land that they can hunt on. So you're walking up a knob trying to go find an elk, or maybe you already found one and you're chasing it down, and you are following your OnX Hunt app, and you are exactly where you should be and can be, and suddenly you run into a no trespass. Hunters typically, because the burden is on them to know where they are so that they're not trespassing, will look at that sign, and even though they have maybe the OnX, will not pass that sign in because they're trying to be conservative and not break the law. They want to be lawful hunters. They don't want to be, shamed as poachers, and so they might not be able. They just might not go past that. New hunters especially. And so part of the issue is right now you could call potentially BLM to assist you with that, but if it's state land, probably not. And what I've heard from testimony and on the other side's committee is that's often difficult to do. We don't know how to find somebody, or they just don't get through. And so the problem is still there. Game and Fish runs most of its budget from hunters and anglers, but they don't necessarily in this instance, they can go and a landowner can call Game and Fish and say, somebody's trespassing and they're hunting, come take care of it. But if they are lawfully trying to hunt and someone is trying to infringe on that right, which is a constitutional right in our Wyoming State Constitution, there's really not much discourse for them. So what this bill does is tries to kind of rectify that and ensure that if someone is unlawfully trying to stop someone from lawfully hunting on their land, their public land, then a citation can be given to that landowner. But really, I think 90% of the time people don't want to break the law. And this might just stop them from doing it to begin with, or it might just take a phone call or a visit from Game and Fish saying, you don't own this land. And so we're not going to necessarily get folks who aren't trying to do this on purpose. So that I can walk you through the bill real quick, and I do not have the engrossed version on me, but I think I've ingrained in my brain what we did. Basically, in the original bill, we had no person shall, with the intent to prevent or hinder the lawful taking of any wildlife, is that paragraph A. And then we had knowingly, thank you, good country lawyer. Knowingly and without authorization, post or maintain in place signs that restrict access to or use of state or federal land on which the lawful taking of or the process of lawfully taking any wildlife is permitted for purposes of this subsection. Knowingly means the person has received prior notice from a peace officer that a sign is located. This was a third reading amendment. So if you look at the original, the white bill, you'll see that we don't define knowingly. I don't think we've defined knowingly in our statutes typically, kind of let the courts decide what is knowingly. It's kind of like our reasonable doubt definitions, a doubt based upon reason, just kind of up to a jury or the court. And so what there was questions on the bill about what is knowingly. So I think the Good Country Lawyer was trying to solve an issue that may have been in the House in terms of what knowingly is, but I'm concerned that what that third reading amendment did was maybe kind of goof up or make it complicated with that paragraph C that you'll see not in this, not in the bill itself, but in the statute under that 23-3-405. So I'm happy to stand for questions, but yeah, the intent of the bill, not to get a gotcha on anybody, just trying to make sure we have fair on both sides.
Questions? Senator Baldwin.
In that, excuse me, Representative, in that paragraph on page 2, you were talking about three little eyes. Just one term there that doesn't bother me, but a question about, it says a peace officer. Is there a definite, I mean, is that somebody from the BLM is not necessarily an enforcement officer or somebody from the Forest Service or whoever? Where do they fit in under there? If they're advised by a BLM range conservationist, then they don't fall, they haven't been notified. It actually has to be a peace officer. Is that how I'm reading that?
Representative?
Thank you, Madam Chairwoman. So peace officer is a lot of different things. I don't have that definition in front of me. I believe it's in Title VII. But essentially it could, I believe it does include the Bureau of Land Management. And certainly I think it would include Game and Fish because they have authority, but you might have that in front of you, Senator.
I'm betting, and I don't have it in front of me, but I'm betting that it includes their enforcement officers from the BLM, but not their range conservationists, their forest conservation, et cetera. So it may be something we may want to look at, because if they've been notified, just clarify who's notifying them.
Other questions? Follow-up? Oh, Senator Ellis?
Thank you, Madam Chair. Along those lines, on line 4 on page 2, knowingly and without prior or without authorization post. So now we have 2 requirements, the knowingly and without authorization. Does it work better with just having one? Without authorization or knowingly post or maintain? Because, or do we change it to or? Knowingly or without authorization, post or maintain? It's a silly thing, but this requires 2 things that have to be satisfied.
Representative?
Thank you, Madam Chair and Senator Ellis. You're right. I think it does include, it creates kind of different prongs, right? And so if you're with that original version of the bill, without that peace officer issue in it, what we have is then knowingly and without authorization, post signs that restrict access to or use of state or federal land on which the lawful taking of or the process of lawfully taking any wildlife is permitted. So we don't have those same kind of prong issues with what is knowingly, who's the peace officer, who's responsible for contacting these folks. And so I think ultimately that's part of why that third reading amendment you might want to consider, does that help the bill or does that kind of create confusion? Because I don't think we need more prongs in terms of the intent of the landowner, because in paragraph A, we've got no person shall with the intent. So that automatically is already kind of a good backstop for private property owners. If they're not intending to do something, then they're not going to fall under this issue, right? And that's where Game and Fish can say, you know, I have discretion. I don't think that you had intent to do this. Could you take the sign down? And I think vast majority of folks would do that. And then we have knowingly in that paragraph. I don't know that we necessarily need to define it because we have so many protections as the bill was first drafted to protect landowners from potential issues with Game and Fish.
Senator Baldwin?
Yeah, and I just actually, our good secretary just brought me the definition of peace officer. And interestingly, the BLM, Forest Service, et cetera, aren't included in there. It says, no, they're not.
Oh, no.
Any peace officer means any duly authorized sheriff, undersheriff, or deputy sheriff, any duly authorized member of a municipal police force, college or university campus police force, or the Wyoming Highway Patrol, and Game and Fish law enforcement personnel qualified pursuant to 91701. So those far,
I guess with just looking at this, just off the top of my head, I would propose just taking a peace officer out of there and just put that they have been notified without emphasizing who notified them, just a future amendment that I would make.
Representative, how do you feel about that?
Thank you, Madam Chair. Yeah, I certainly think taking out that peace officer would be beneficial, and allowing for notification. I think if you leave it without that peace officer in it, then it could, you might have questions about confusion of like, well, did the hunter notify you? Or, yeah, there might be some ambiguity there, but I would defer maybe to Game and Fish. I mean, ultimately, this statute would fall under the Game and Fish title, right?
Madam Chair?
Yes, go ahead.
Just because it's an educational day, so the Bureau of Indian Affairs has the Wind River Police Department. They've all gone through law enforcement training in Artesia, New Mexico, and they're fully law enforcement, but they are not considered peace officers under Wyoming law unless they go to the Peace Officer Academy.
There you go. Interesting.
The more you know.
The more you know. Okay. Other questions or comments for good representative? I got a few emails about this, and it was interesting on both sides of the issue. But it seemed as though most of them were geared towards the fact that maybe these things have happened in the past, and there have been some concerns from our hunters about maybe some overreach of some landowners and some of the folks that work for them. So interesting bill, I think. I don't have any questions. Anybody else? All right, let's move on then and take testimony from anyone in the room that would like to testify on this bill. Welcome. Please introduce yourself,
Great, there we go.
even though we may know you.
Thank you, Madam Chairwoman and members of the committee. My name is Sabrina King. I am representing the Wyoming chapter of Backcountry Hunters and Anglers. And just to give a little bit more background on kind of where we're coming from on this bill, and then I'll get into the statutes a little bit more. But last fall, BHA did a survey of its membership, basically just to ask, what issues are you encountering in the field? And, we've been having a lot of conversations about public lands access, and we wanted to kind of see like, what really are our hunters kind of encountering and what are the barriers that we're facing? And honestly, this was issue number one. And it was really surprising, I think, to me and to some of the other folks, because I think anecdotally, and it's been interesting working on this bill because every person I talk to has a story about this, of encountering a sign that they believe is an improper known trespass sign. And the number of times that I think in our community we find questions about who do you call when that happens? How do you actually deal with this issue? One of our biggest goals this session, but also sort of moving forward as backcountry hunters and anglers, is to find ways to de-escalate conflict between landowners and hunters, especially in the trespass space. And so for us, if we have hunters in the field and they come across a sign and they believe that they're on public land, we want to be able to tell our folks, call Game and Fish. There's actually a really easy way for you to figure out, are you on public land or on private land? And to answer some of those questions. And 99% of the time, these issues can be dealt with a conversation. But I think in those instances, and I think we have some stories to this effect of where there is very intentional action on the part of a landowner to prevent someone from accessing legally accessible public land to hunt and fish. We want to be able to have a way to call our Game and Fish department and have that issue taken care of. So in this bill, and as the good representative said, we're really not trying to do a gotcha. We're not trying to get folks who maybe, think their property line is here, but it's actually over here, or post a sign and just don't know. The underlying statute 233405 is commonly referred to as the hunter harassment statute. And there is some pretty good language in there about intent. I think in the bill where it talks about knowingly and without authorization, that could be, or I think what we're trying to get to there is on state lands or the grazing lands, if a landowner has been told like, yes, you can put up a sign, again, we don't want to have a gotcha. So I think if that changes to or, that could be fine. In the underlying statute in subsection C, and I think this is where on page 2, that line's 8 through 10. I think that was the amendment that was referred to on third reading in the House. I think that can just completely come out. I think in the underlying statute, subsection C does say any person failing to obey an order of a peace officer to immediately desist from conduct in violation of subsection A of the section is guilty of a high misdemeanor. So there's already a provision in the underlying hunter harassment statute that provides for notice from a peace officer. And so I think what was amended in the House may conflict with that. So I think just taking out those lines could be helpful. And also just for reference, so the committee knows, in the underlying hunter harassment statute, subsection G, it does say that the subsection does not apply to any landowner or his agent engaged in any activity on his own private property. So there are provisions in the statute already for notification from a peace officer and ensuring that landowners, when they are doing legal things on their own land, are not affected by this statute. And so I think that maybe didn't come up in conversation so much on the floor, but I think as we've digged more deeply into the statute, we don't want to have kind of conflicting provisions. So I think lines 8 through 10, if those could come out, would be helpful. But otherwise, I will stand for any questions. And I think this is an issue that our hunters are finding in the field. And I think if we have a way to sort of bring in outside support rather than having, hunter-landowner conflict directly, that would go a long way, I think, in getting us down the road of having better relations in the field.
Questions for Ms. King? No, I appreciate the fact that at least anecdotally, your backcountry hunters and anglers have brought this forth, because I think that's why we do what we do with these bills, is to try and help our constituents on both sides of the fence. And so if we can help out and try to make it a peaceful situation for both sides, I think that's good. So I think that's a pretty good catch. I don't have any questions. Does anybody else? Okay, thank you. Appreciate it. Anyone else who would like to testify on this bill? Come on up. Welcome. Go ahead and introduce yourself, even though I think we all know you.
Thank you, Madam Chair. Jim McGagnon with the Wyoming Stockgrowers Association, also representing the Wyoming Wool Growers Association today. And as amended in the House, we are comfortable with this bill, that it protects landowners' rights and addresses an issue that in few instances, we think the instances are not commonplace, but there are instances where state land in particular is perhaps being improperly posted, and I believe this addresses it. There is one scenario that I think of that perhaps this addresses, perhaps it fails to, and that is on state trust lands, by decision of the Board of Land Commissioners, public access is allowed, but no overnight camping or campfires. And in some instances, the Office of State Lands and Investments has posted signs on state parcels that say state land, no overnight camping, and no fires. But in a lot of cases, they haven't posted those lines because they simply aren't out on every piece of land. They don't have the staffing to do that. And I'm aware of instances where a landowner on a parcel of state trust land may post a sign that says no overnight camping, for example. Would want to make sure that, because that's not a legally allowed activity, they're not in violation of this statute if they were to put up a sign of that type. Ideally, I would say on line 5, maintain in place signs that restrict legal access, and that would tend to cover it by adding the word legal in there. However, I would assume even without that change, that a peace officer would not direct the landowner to remove a sign that said something that was already illegal on the land. So it's likely covered, but it would just be a little clearer with the insertion of the word legal there. Beyond that, we do believe that even though knowingly is in the broader statute, that defining it here to receive prior notice is important, just as we often hear that a sportsman, for example, even with the use of GPS technology in that, which is not 100% perfect, may end up on some private land because of inaccuracies. In the same manner, a landowner may, because of inaccuracies, place a sign thinking they're placing it on their private land, but in fact have placed it over the line onto some state or federal lands. So I think that the needing the notice from the peace officer is critical here, because it means that there's been an independent third party who has analyzed this and determined that, yes, the sign is improperly placed. With that, Madam Chairwoman, I'd be happy to entertain any questions.
Questions for Mr. McGagnon? Yeah, Senator Ellis.
Thank you, Mr. Chair, or Madam Chairman. I don't want to tinker too much with your bill or this bill, but I think there's that piece that's bothering me. Right now, the person has to have intent. They have to knowingly do something. And I think the way this is structured, the knowingly is meant to be somewhat of a proxy of proving the intent. So to me, those two are kind of combined. But then it's and without prior authorization. So that's the one piece we haven't talked about. Like, how does that fit into this without prior authorization? If they have authorization, then it should be okay. So that I'm wondering if we need the and without authorization. Just a person knowingly posts or maintains these signs.
Mr. McGagnon.
Madam Chair, Senator Ellis, I would feel that we do need to keep and without authorization, and that, for example, the scenario I just explained with state trust lands, because certain uses are prohibited on those lands, I could argue that I have authorization to post something that is in fact covered in the statutes, where just knowingly place signs that restrict access, arguably, I know it restricts access, but I couldn't argue that I have authorization because of a particular use, or even on federal lands. If I have a permit, whether it's a grazing permit or some other activity on federal lands, say an energy development on federal lands, I may knowingly post a certain area as no public access, but I have authorization because of whatever my permit is, whether it's a drilling permit or a grazing permit, whatever, that permit specifically authorizes me to, for safety or other reasons, to keep the public off of a particular parcel of land. So I would see a need for authorization in order to cover those scenarios.
Madam Chair, so
Yeah,
follow-up,
follow-up,
could
go
it be or then, knowingly or without authorization? And I think we can't forget the language on line 2 and line 1. This is a high bar. They have to prove intent to prevent or hinder the lawful taking of wildlife. Like, that's the magic language that doesn't quite address what you're talking about when it comes to no overnight camping. If a person posts a sign along those lines, their intent isn't to prevent taking. Their intent is to offer information about no overnight camping, right? Like, so I just want to make sure we're getting it right, because right now there are 3 things that we have to be thinking about: the intent, the knowingly, and the authorization piece. So I'm just trying to think of, that's a lot to me to cover. Like, can't we just do 2? Like, intent's already high, now we're adding knowingly or without prior authorization. That's what I'm trying to piece out.
Madam Chairman, Senator Ellis, I believe that I would be comfortable with changing the and to an or, because if you have authorization, then you're protected. I mean, if you don't have authorization and you do it knowingly, I think that would be acceptable.
Other questions for Mr. McGagnon? Okay, thank you for that
Thank
information.
you, Madam Chair.
Appreciate it. Representative, did you want to weigh in on this? I saw you shaking your head, so I'm assuming you wanted to.
Chairwoman Schuler, committee, Senator Ellis, I don't think we want to take the word and out, because then we create 2 tracks there. And the whole point of the without authorization part is this could apply to your game and fish agents. It could apply to your BLM agents who actually go out. There are certain areas that are restricted from hunting, even though they're public. So the with authorization was not only, I think that was also put in there to protect our agents who oftentimes, whether it's state land agents, game and fish, BLM employees, they put up signs that restrict hunting on certain parcels of property. But as I look at that, if you take out the word and, you then create 2 separate tracks, because we're really talking about a negative at that point. And so, sorry. So you could then be, if you knowingly, even if you have authorization, could be subject to the crime, or vice versa. And so I think you have to keep in the and, but that's just my opinion as I look at the language.
Questions for Representative? Okay. No, we have, oh, go ahead.
I'm sorry, I
Yeah,
wasn't
okay.
quick and you were
Someone else?
fast. Madam Chair, Representative Crago, you heard, Senator Baldwin talk about kind of the limitation of peace officer. And so have you given any thought as you were sitting there, and you're more familiar with this bill than I am, a better proxy for peace officer?
Representative?
Chairwoman Schuler, Senator Ellis. So I'm the one that put that in. The reason I chose peace officer is so that there's a record, so that it's very clear who gave the warning, so that we're not getting into a he said, she said, because I actually think if you don't have the peace officer give a warning, you're just allowing for escalation between the hunters and your private landowners. Whereas if the hunter just calls up and says, hey, this rancher has put a sign in the wrong place, would you please come warn them? They then show up, give the warning and say, and by the way, I don't think it contradicts the next paragraph within that section, because immediately they know they're out of order, right? They know that they need to remove the sign. And if they say, I'm not removing the sign, even though they've been warned, they get a ticket. I mean, if the game warden's standing right there with his GPS saying the sign's in the wrong place and the rancher fails to remove it, they get a ticket. I mean, what that was intended to do when we put it in on the House side is there are lots of places, not every rancher has a GPS, right? And so there are lots of places out in the backcountry where these signs are up and maybe they're in the wrong place, but the rancher didn't intend to put it in the wrong place, right? And so that's what we were trying to protect with that particular language. And so if a hunter comes across it with the GPS, most hunters nowadays have those and say, hey, that sign's in the wrong place. They can call law enforcement, which is usually going to be your local game warden, and say, hey, that sign's shouldn't be there. Game warden can then contact the landowner, have the discussion, say, hey, you need to remove that sign. I mean, I'll give you an example. One time at our place, BLM contacted me and told me we had a sign in the wrong place. I said, no, I don't. And so we went out with the GPS. I have my GPS, he has his GPS, and I actually have my plat map for the entire ranch. So we go out, their GPS had not been updated for years. And so they had the wrong location. And so us going and talking about it solved the problem. He said, oh, I guess you can leave your sign there. So that's the thing we were trying to just work around it so that law enforcement can talk to the landowners prior to somebody just getting a ticket.
Makes sense. Any other questions? Any follow-up? Okay, thank you for that information, Representative. Any other testimony? Come on up. Welcome. Introduce yourself, please.
Excuse me, Chairwoman Schuler, member of the committee, Josh Meck, the Roosevelt Conservation Partnership, out of Cody, Wyoming. We're on for the bill. I think that this bill and others like it are part of a bigger conversation surrounding improving access to public land in Wyoming. I'd like to emphasize previous comments about that being the top priority for our members as well. We surveyed our membership in Wyoming, and that came out widely as being the most important issue is access. We think that one of the things that we like about this bill is it seeks to de-escalate conflict. We want to be able to provide managers, decision makers, peace officers with the tools that they to resolve and discourage bad actors. And we also want the public to feel like they can report these issues and that it will actually get done, rather than feeling that they don't have any power to resolve issues and then they consider taking matters into their own hands. So yeah, as I've mentioned, this is an issue that occurs across the state. I've heard reports from our membership in over in eastern Wyoming, over in the west slope of the Tetons, all over, and we support this bill. And I'll stand for any questions.
Questions? I have just one. A good point that was brought up by the GPS. I wondered about the GPSs. I thought they were 100%. I thought they were right on. But do you have issues, or have you heard of issues where people haven't updated their GPS and that causes some of the issues? Or is it just a problem sometimes with landowners that don't own them or don't use them? Or what do you think the real issue is?
I wouldn't say I'm an expert on GPS, but in my own personal experience, we've rapidly moved towards using our smartphones as our GPS apps, and we're expecting this amazing technology, these computers in our pockets, to be able to communicate with satellites high above us, and so sometimes they come back and give us bad information, and so yeah, I think that having a due process to address these issues, and again, we're seeking to encourage better relationships between the public and landowners. As an organization, we really support private land. There's a lot of habitat on private land. It's something that we work on both on a state level and a national level to encourage conservation on private land. So we're here to support private landowners. We're here to support the public as well.
Any other comments or questions? Okay, thank you so much for your testimony. Appreciate it. Anyone else that would like to testify? Morning.
Good morning, Madam Chair, members of the committee. Jess Johnson with the Wyoming Wildlife Federation. I'll just keep this short and sweet since everybody has sort of testified in front of you. We stand together with TRCP and Backcountry Hunters and Anglers in support of this bill. As I mentioned before, the de-escalation of conflict between hunters and landowners, I think, is something that's at the forefront of a lot of our minds right now. And sort of where we can move this discussion, from, and I think where we hope this future goes, sort of from the trespass vortex that we seem to be stuck in right now, all the way to like an access discussion where we're all sitting at the table, we're all talking over it, we're having sort of good faith work between landowners and hunters. That's what we're interested in. This bill seems to start us there and starts getting us there, so we're very much in support of it.
Questions for Ms. King? Okay, thank you for your testimony. Appreciate it. Anyone else? I noticed we have a good director there, Mr. Chief Game Warden. Do you have anything you'd like to add, or you didn't know if you were interested in weighing in or not on this? Hate to put you on the spot if you don't want to be. You can always say no. Welcome.
Good morning, Madam Chair, members of the committee. My name is Rick King, Chief Game Warden with the Wyoming Game and Fish Department. And I think you've heard a lot of great testimony already on this bill, and really will stand for any questions that you might have. I would address one piece that you've already discussed, and that's peace officer. And I think for state law enforcement purposes, the definition of peace officer is sufficient in Title VII, and federal officers, either BLM rangers or Forest Service agents, they have their own authority under federal law just on federal land. So they already have this ability to address unlawful signs, but this would create the ability for a state peace officer under Title VII to address concerns. So other than that, we stand for any questions that you might have.
Any questions for the chief? Senator Ellis.
Thank you, Madam Chair. I'm just still trying to, on the without authorization, and just trying to think this through. I mean, if the BLM or the Forest Service or a federal agency said, no, you can post this sign, or state lands, how do they prove, I mean, how do your folks out there prove that they have that? Do they have a letter? I'm just, this prior authorization just seems really nebulous to me. And I just want to, I mean, as I read, I think knowingly post or maintain a sign is sufficient. And I heard testimony, as you did, about the without authorization could maybe include those federal agents, but doesn't say that. So I'm just struggling with it. Do you have any thoughts on that? Or explain to us how that works out in the field?
Chief King?
Madam Chair, Senator Ellis, I think there really isn't a formal process that I'm aware of. What I would envision is this would be a case-by-case scenario where if our officers got called to investigate a sign, we'd probably have to coordinate with the federal agency to determine whether or not it was actually in the right place or not in the right place, whether or not it had authorization or didn't. So what I would envision is that this would be a lot of case-by-case investigation by our officers or whichever peace officer was called to handle it.
Follow up?
So as a follow-up, so that's the piece I'm wondering. If you're investigating this and you have the language that says no person shall with the intent to prevent or hinder the lawful taking of wildlife knowingly post or maintain a sign, Then we have this definition of knowingly, that the landowner had to have prior notice. If we took out the without the authorization, wouldn't you still, if you're investigating where the sign is placed, call the federal agency, say, hey, do you have a relationship with this landowner? Did you tell them that they could put the sign? And they say no or yes, and that, wouldn't that, is that something you would do in the normal course of your investigation?
Right, Chief?
Madam Chair, Senator Ellis, yes.
Thank you. Okay. Any other comments or questions? Okay. Thank you so much for your testimony.
Thank you.
Anyone else? Oh, another chief. Welcome. Glad to see you.
Thank you, Madam Chair. Byron Odikoven, Executive Director for the Wyoming Sheriffs and Chiefs. Initially not thinking I would testify and thought I might throw a little mud in the water just barely and still support the bill and provide a moment of education. For further clarity, when it comes to federal officers enforcing state law, they can't, clearly, but they can enforce federal law on federal lands. So I think it was described that they have that authorization on signage now as it relates to federal lands, but they would not have any authority to enforce or discern state land sign issues, only federal land sign issues. And I would agree that the definition of peace officer is adequate, sufficient, and correct for this type of law as it relates to peace officers' enforcement authority. To the term of discretion, I like the fact that we have a degree of discretion in here because we also find that we have a number of fences, quote, as a matter of convenience, end quote. So the gate accessing that property might be 150 feet off the property line because of the ridge, because of the rocks, because of the river, because of the something that causes that fence to be moved over, and all parties agree except the maps, so to speak. So there should be a moment of discretion to sort out that signage as a matter of convenience can cut both ways. It can either allow more access or less access, depending upon how that particular tract of land lays. For a period of time, for example, in northern Campbell County, we discovered that the surveyors at the turn of the century, when east met west, agreed that the pin was 3 miles separated. So the pin on the east and the pin on the west were in the same place. They just happened to be 3 miles apart. Took a few years to sort out where those property lines were, and it did involve some federal lands as well. So there was kind of controversy. If you started from the east and worked your way west, you were there. But if you started from the west and worked your way, or the other way around, east to west, you weren't. So it was kind of a little interesting. So a degree of discretion in enforcement is likewise wise. In terms of the additional language for and, if you will, an authorization, I know from personal experience that part of what I end up with is a letter from the agency that says, go post the sign. I haven't got a clue who to call to find out if that's true, but I do have a letter. And I know from experience as well, finding some of that notification or call, which office even handles it, whether the person's even still there on vacation, you pick it. Sometimes finding that information is a little difficult, but we usually have a letter or ask for that letter to be able to have that degree of authorization that can be shared. Not always timely to be able to retrieve that, but certainly part of that investigation going forward would allow that ability as well. And times do change. As we mentioned, the oil, gas, minerals exploration issues, there's property that's allowed to be trespassed on that changes this summer, which reverts back depending upon some of the federal regulations as well. So it can be a moving target, no pun intended, that requires a little investigation and discerning and discretion going forward. But we support the bill and suggest that we do need the additional language to ensure it takes in some of those that I've described. Madam Chair.
Questions for Mr. Odekoven? Senator Ellis?
Thank you, Madam Chair. Do you have a thought of how to tighten up the without authorization? To your point, you said, what if it's a federal agency, they have a letter, but maybe some, I'm guessing in my mind, that would be the tie-in if we said a letter from the public land manager of the land that are being trespassed on? I know that gets clunky, but that's what I'm getting at. That's who can authorize it. This is just a little open-ended for me.
Mr. Rotocoda?
I have authorization from my neighbor to post this, right? Like, well, do they have the authority to provide that authorization? I'm overthinking this, I know, but.
Go ahead.
Madam Chair, at the risk of finding a fine opportunity not to answer, I think I shall make an answer brief. I realize that it appears to be somewhat clunky, but I think it's also designed to take in a multitude of options and scenarios as you work your way down that compendium of, okay, where are we at in this deal? Do we know? Are we authorized? By whom? Do you have it? You know, you kind of work your way down through the statutes. And part of my mind, or part of the description is, if an officer at 3 p.m. on a Saturday or Sunday is out there trying to discern whether or not the landowner is doing this correctly, he needs to look at the statute and be able to follow along. If we have it clear to be able to follow along, then we've done our job here to provide that guidance that he's not going to receive from anybody else on that Saturday afternoon. Madam Chair.
Madam Chair.
Yeah, follow up.
Madam Chair, I don't know why I'm just on fire this morning. Should just let this go. On line 4, what about knowingly and without appropriate authorization? Does that help it? Appropriate?
Mr. Rotocoda, over to go.
Madam Chair, I think that would be my time to turn to the person described as the country lawyer, who would be the county attorney that we would call to try to clarify for the officer in the field before we issue same and said citation that you're thinking we're contemplating we would issue.
Thank you. Other questions or comments? Yeah.
Thank you, Madam Chair.
Thank you for your testimony. Appreciate it. Anyone else in the room that would like to testify on this bill? Okay, do we have anybody online? Okay, we do.
Madam Chair, we have Zach Dorr online.
Okay. Will you let him in? Thanks. We're having some technical difficulties. We see his name. Mr. Dorr, are you around? Are you close? Are you out in the back country? Okay.
Madam Chair, we also have Levi Jensen online if we would like
Okay.
to go to
Why don't we
Mr.
go to,
Jensen.
why don't we go to Mr. Jensen while we're working on the other gentleman? Welcome, Mr. Jensen.
Morning, Madam Chairwoman. My name is Levi Jensen. I live up in Gillette, Wyoming, here representing myself. Just add a little bit of color to the conversation about GPS accuracy and maybe some of the situations that I've run into personally on this. I gave similar testimony to the House committee that heard this bill first. I've run into 2 situations up here around Gillette that improper signage was put in place. Both of them, GPS accuracy, wasn't really an issue in those cases. Clearly, those 2 signs were put there intended to restrict access and probably primarily for hunting purposes. One of them was along a cheetah road that would give access to I think it's like a 40-acre BLM parcel. I called the BLM office. BLM in Buffalo has 1 enforcement personnel for the entire region. I don't know if they ever got to that one to take that sign down or inform the person that put it there that it was improperly placed. The other one was down in the Thunder Basin National Grasslands, and it was along a 2-track road, kind of at a really good place to be a little uncertain if the road continues on, but it was on the motor vehicle use map, and The private land wasn't too much further beyond that sign. But I was comfortable in that situation to just drive on past it. I was able to defend myself with the motor vehicle use map. If the landowner approached me that I passed the sign, I felt comfortable that, yeah, I'm in the right here. But in both of those situations, it would have created a scenario where, it would have messed up my hunt for the day. If I would have had to call Forest Service enforcement personnel or BLM enforcement personnel, and it just takes a lot of time for them to get out there. Game and Fish, they're out patrolling during the seasons, and they could be there within a matter of hours or something like that to de-escalate that situation. And that's primarily why I support this bill. I don't see it as a way to squabble over fence lines that are off. I don't see that as an issue that this bill is really trying to address. It's those signs that are put there, really to in the wrong place to restrict access. And that's kind of why I stand behind this bill. With that, I stand for any questions, or I don't have a lot of input on the ands versus ors, or, playing with the language too much. I think it works fairly well as written, but as always, you could tweak language to make it better.
Thank you, Mr. Jensen. Questions for Mr. Jensen? Okay, thank you so much for your testimony. We appreciate it.
Thank you.
Very helpful. Is Mr. Dorr back up and running? So we may not have his, okay. With that, then we'll go ahead and move forward. What's your pleasure on this bill?
Move it.
It's been moved by Senator Baldwin, second by good senator on the end there, Mr. Mike Garou. What's your pleasure on this bill in terms of amendments? Anything on page 1? Comfortable with that? Okay, it looks like page 2 is where all the action is. So what are some of your thoughts on page 2? Senator Baldwin.
Ma'am, after talking about that in testimony, I decided I don't want to change it. I think it works the way it is after all the explanation. Just as a point of punctuation here, I brought up my Onyx maps while we were sitting here. And according to my Onyx maps, I'm about 50 yards north of Representative Crago's desk.
Okay.
So
they're pretty accurate.
Always not accurate. Well, I'm a long ways from his desk, but that just being a case in point. Some of that's, we're inside some walls, but
Sure.
they're not always 100%
Gotcha.
accurate. But anyway, that given, I think it's a good bill. I got some personal experience with it. And I would further muddy the waters. It's not always landowners that do this. It's other hunters. It can be a lot of different, coming from a lot of different places. And I got shut out of a piece of very public land that was well within by someone in a county unnamed, because he had great bull elk in his land. And it was clear, and he went as far as his hands would come out and chase us off. They fired shots over our head, et cetera, et cetera. I think this bill is helpful to that situation, and I will support the bill.
Okay. Other comments? Senator Garou.
Thank you, Madam Chair. On item 4, sorry that I came in just a little bit late on this one, so I'm going to be supporting the bill as is right now. I still just got in the middle of that discussion about the words without authorization. I too would like to kind of think about that a little bit and, just kind of, I'll wait for the floor. But for now, I think I'll just leave it out the way it is. Thank
Okay.
you, Madam Chair.
Thank you. Comments? No? Anyone else? Okay. So no other additional amendments? We're not gonna mess it up, I guess, then, hopefully.
Not
I guess if we think about it for a day, we might, but, all right. There's no other questions or comments. Let's go ahead and take a roll call vote.
Thank you, Madam Chairman. Senator Baldwin,
Aye.
Senator Ellis.
Aye.
Senator Garou,
Aye.
Senator Jones, and Chairman Schuler.
Aye.
We have 5 ayes on House Bill 147.
Okay, that bill is passed. We'll take a listen for it up on the floor.
Who would like to
And-
present?
Any takers on this one?
Thank you, Representative.
I think there's a,
Oh, Senator Cooper. Okay.
you're on there too.
Oh, yes, I am on there. Yeah.
Thank
Well, I
you.
was trying to avoid me. That's what I was trying to do. People get tired of hearing some of the same folks, so. Thank you. All right, for our last bill, House Bill 126, this one is trespass, removal of trespasser. And we're back to our good Representative Crago. Welcome.
Thank you, Chairwoman Schuler. Committee members, I bring to you House Bill 126 this morning. ask for your favorable consideration. This is actually a constituent idea. Gentleman from my town, Buffalo, he teaches church security. And we'll hear from him here in just a minute. But this actually came to me from him. And he explained to me as he teaches these classes, one of the main questions he always gets is, so if someone's causing a ruckus in church, can we grab them by the arms and throw them out? And he said, yeah, that's the common law. That's, we can do that. If you're afraid, especially if the situation is about to escalate, get them out of the church or get them out of the building, whatever we're talking about. And so whichever building it is. And so everybody else always asks him, okay, well, where can I look that up? Where is that law? Well, in Wyoming, actually, we don't even have case law. There's a few cases where it was used as a defense in a criminal action, but we don't even have civil case law. Nothing has made it to the Supreme Court. And of course, we don't report anything that doesn't go that far. And so we don't have it here. Some of our surrounding states do. And a lot of our surrounding states have passed the language and put into statute language that's almost identical to what's proposed in this particular bill. Some of those include, and I just did the research on myself. I didn't ask LSO to do a whole memo for me, but for example, I have statutes with me today from Arizona, Alabama, Texas, Connecticut, and Maine, and those were literally the first 5 when I typed it into my search engine, my legal search engine that I use. Those were the first 5 that came up when I just typed it in. That's what I got. And so what this bill really is trying to do is make the law more transparent. Here's what that law actually is. Here's the requirements on that. And of course, as you read it, it requires two levels of reasonableness. It says a person who is the owner or legal occupant of land or a premises upon which a criminal trespass is occurring, or their agent is justified in using reasonable and appropriate physical force. So that's the first reasonableness standard necessary. Upon another person when and to the extent that it is reasonably necessary. And actually, I think that one's the more important one. But reasonably necessary to terminate what the owner, occupant, or agent reasonably believes to be the commission of a criminal trespass by the other person in or upon the land or premises. And I think there's a lot of people that think this is about hunting and corner crossing and all that, and it has nothing to do with that. And Mr. Gray, when he gets on here in a little bit, will fill you in on why he believes it's an important addition to our green books. But you're going to hear, I'm sure that you're going to hear testimony about how this is going to allow, ranchers and landowners to kick people off. I actually don't think it will allow, it's not going to allow you to do that because you still have to pass the second reasonable test. Is it reasonable to grab somebody and throw them off your land out in the middle of nowhere when they're just trying to leave? I would argue no. And so that's sort of my retort and I'll be happy to answer any questions when we get to that point. But that's really the idea. This is really geared towards, I think our society is changing, right? And we have all these shootings, we have stabbings, and what we're trying to do is let people know, hey, if something's occurring, you can take action. If you think something bad is about to happen, get the people out of the building. Don't question whether or not you have the legal right to do that. Just get it done, which I already know the law that you can do that. Senator Ellis probably knows that as well as a practicing attorney, but most people aren't that. And so they shouldn't have to go ask a lawyer to figure out this particular law. And I think that's what Mr. Gray will tell us about. So anyways, I'm happy to stand for any questions at this point or later if you wish.
Questions for Representative? I'm surprised, I'm shocked. Okay. We may have some later though, if you've got a minute to hang around. All right, thanks. Testimony on this bill from anyone in the room? Come on up. Welcome back.
Thank you, Madam Chairwoman. And again, Jim McGagnon, Wyoming Stockers Association, Wyoming Wool Growers Association. We very strongly support this legislation, visited with people in other states who have been helped by this. And the scenario that we think of is that we have people have lands out long ways away. If someone is trespassing on your land and actually, if they're actually doing damage, they're driving through in the mud and creating ruts in your alfalfa field, or they're significantly harassing your cattle, or whatever that may be, or even your family. And law enforcement is hours away in many cases. So this would provide them the ability to take reasonable steps to stop that from happening without having to do nothing until appropriate law enforcement shows up. And by that time, the damage has been done. It could be very significant damage to person or to property. So we think that this has worked well in other areas, and it makes sense as giving some teeth to private property rights. Obviously, in the case if it's in a facility, in a premise, but even out on the open land, if actually in the scenario where the landowner feels that immediate action is necessary to protect them, their family, or their property. With that, Madam Chairman, I'd be happy to answer any questions.
Questions for Mr. Magagna? Yes, Senator Ellis.
Thank you, Madam Chair. I'm just wondering, the bringer of the bill mentioned that we don't have a lot of our opinions online, but that's changing. Yay, yay us, yay Wyoming, we're getting there. But so this does apply to criminal trespass, and I'm trying to look up the definition, and I think, the person's not authorized to be there, and then they receive notification to leave. And that's when their presence becomes criminal. I'm just wondering if you have any numbers that can substantiate how often this is happening where someone refuses to leave. I think that what I tend to hear most of the time is, someone's unlawfully there, the landowner says leave, the person says okay, and then it's over. But I'm wondering if you have any data on how many times they say, no, I have a right to be here, or how that kind of works out there.
Mr. Magagna.
Madam Chair and Senator Ellis, I don't have any numerical data. I've heard of numerous examples of where it's happened. It tends to happen more often with non-residents who come into an area, and particularly if a scenario where the private land is so intermingled with the public land, and they're on the private land doing something, and they're thinking, well, because this is the access to the public land, I can do what I want on here, and you can't tell me to leave. And I do hear examples of that scenario.
Follow up, go ahead.
Follow up, Madam Chair. And then I'm just curious what, in your view, what reasonable is. I think even in the law enforcement context, we see that peace officers are trained in our societies to arrest and detain people, and sometimes that goes horribly awry and people die. So excessive force, that's not okay, but that's what, on the larger national conversation. So that is my concern too, is, I think to each individual, that word reasonable might differ. And so I'm curious to know what you think is the maximum amount of reasonableness, like grabbing the person, putting their head on the ground, tying their hands behind them. Is it an arrest type situation? I'm just trying to get my head around what we're saying is okay.
Madam Chair and Senator Ellis, I think that the definition or the determination of what's reasonable necessarily needs to be someone on a case-by-case basis. If they're threatening my kids, maybe tying their hands behind them and putting them down on the ground and holding them until law enforcement arrives would be very reasonable. If they're just doing some property damage, that probably in most cases would not be a reasonable response, but grabbing hold of them and putting them in their vehicle and telling them to drive off might be a very reasonable response. I think it just depends on the seriousness of the offense that's occurring as to what would be deemed to be reasonable.
Any other questions? Okay, thank you, Mr.
Thank you.
Magagna. Anyone else would like to testify on this bill? Please come forward. Welcome back.
Thank you, Madam Chairwoman, members of the committee. Josh Metton with the Theodore Roosevelt Conservation Partnership. As I always said with the previous legislation, this is part of a bigger, we feel like this is a part of a bigger conversation about improving access, and it is very concerning to our members. We're opposed to this bill due to concerns about escalating tensions between landowners and the public. I don't think this is the message that we want to be sending when we're trying to work together to find ways to improve access to public lands while respecting private land. It goes without saying that private land rights are paramount here in Wyoming. This is an issue that should be addressed by trained professionals, law enforcement. We should not be encouraging people to take things into their own hands, especially when we're talking about being out in the field with people that might be armed. Our members are concerned about safe and legal access to public land for themselves, for their friends and their family. And as we've heard, even from Senator Baldwin, there's been examples of bad actors out there endangering the lives of the public. And we don't want to be encouraging this. So we feel that this bill will encourage risky and dangerous behavior. Rather than going this direction, we'd like to see some action to work together and find solutions to addressing the concerns brought up by the bringer of the bill, and also our concerns dealing with public access. So on and against the bill, I'll stand for any questions.
Questions? Okay, thanks again for your testimony, appreciate it. Come on up. Getting your exercise today, some of you. It's early, but it's good.
Yes, ma'am, Madam Chair.
Okay.
Byron Odikoven, the Executive Director of the Wyoming Association of Sheriffs and Chiefs, rising in support of the bill, but I think we need to take a step backwards and see from whence we're coming, if I may. So the bill contemplates an additional piece to criminal trespass. So I think it's important for us to look at the criminal trespass to see where the bill lies in relationship to that. So first, before the bill even comes to play, Section A of 63303, we have to get there. A person is guilty of criminal trespass if he enters or remains on a land or premise of another person knowing he's not authorized to do so, or after being notified to depart or to not trespass. For purposes of this section, it goes on to describe two opportunities for notice: personal communication to the person, the owner or occupant, or his agent by a peace officer, or posting of signs reasonably likely to come to the attention of the intruder. Next. And then it describes the penalties. So we have to take into account that the person we're describing that may be removed from the property is a criminal trespass offense in the first place. We aren't just talking simple trespass. We aren't talking game and fish trespass. We're talking criminal trespass. We're doing destruction. We're doing criminal activity. We've encountered them. We're telling them they must leave in some portion. And then we go to the statute or the bill before you and says when we arrive at that point of a criminal trespass, the person or owner of the legal occupant of land or premise upon the criminal trespass is occurring, or his agent, is justified in using reasonable, appropriate physical force to remove that person to the extent, again, as we go through our second and our third level of reasonable. So I think it's important as the discussion progresses to remind ourselves we're talking criminal trespass. These people are committing a crime in the first place, and we're asking them to leave, and we may lay on of hands in a reasonable manner to further get them to leave the premise, if I may, Madam Chair. We could talk about different descriptions, whether it's bars, businesses, facilities, houses come under a different kind of a discussion in terms of the Castle Doctrine, et cetera. May somewhat still apply, but nonetheless a different discussion. So I think it's important that we focus this in the area that it's described, and that is criminal trespass, Madam Chair.
Questions for Mr. Odikoven?
Yeah,
Senator Grew?
I'll bite. Here we go. I understand what you said about criminal, and I think it's something that has to be borne in mind. My question is, okay, let's walk through the timeline. What's the time difference between the time of knowing about criminal trespass and the time Whereas a landowner, I can, as you artfully put, lay hands on someone. That's the part I'm having trouble with. Let me further illustrate. I'm not a hunter, but I fish, and I'm going along the river, and I know I'm not supposed to get out of the boat, but for some reason, I do. It's in private property, and I do. My line gets stuck, and I'm up in the bushes trying to get it out. That's more my style. And so now, I'm on the bank messing around with someone's private property. Now, in his eyes or hers, as the owner, I think I just rose to the level that you just discussed of criminal trespass. If I'm creating damage in their mind to property, their bush, their property, and now they come and say, you're criminally trespassing, and now watch me grab you and throw you in the river. Is that a scenario?
Mr. Rotokoven?
Madam Chair, I'm thankful I have an attorney right behind me. So about the time the peace officer steps out and the county attorney decides I did, I'll have a little backup. Between now and then, let me suggest that I would doubt that messing with the bush would rise to the level of criminal trespass. And secondly, remember, we must notify them, and they don't leave to boot before we can start of the laying on of hands. You can't go from point A to point Z without satisfying the elements of the statute between here and there. Madam Chair.
Go ahead, Mr.
Notify. How do you notify? Are you sending me a letter, or are you just saying, hey, you?
Mr. Rotokoven?
Madam Chair, that can be verbal, that can be written, that can be lots of things depending upon the circumstance. So it's again, that would be an artful discussion in front of the judge as to whether or not the judge interprets that notification as being adequate for the case at hand.
Yeah. Any other questions or comments? Appreciate the clarification. That was one of the questions I had. I was trying to figure out in my own mind some of the issues of what criminal trespass would, and the first thing that came to my mind was somebody, out driving around someone's cattle, stirring up things, maybe running a cow into a fence or horse or whatever, or shooting at animals on private. I started thinking of all the real serious things. I hadn't thought about the, smaller ones, but I appreciate the definitions.
Thank you, Madam Chair.
Thank you. Other comments or other testimony from folks in the room? Welcome back.
It's trespass day.
Yeah. Exercise day.
Exercise day. Madam Chairwoman, members of the committee, Sabrina King with the Wyoming chapter of Backcountry Hunters and Anglers. And I will say that we're here on this bill, I think, because of the concern from our members, as we've talked about the escalation of conflict in the field. And I will say with that, I understand the intent of bringing this bill forward. And I think what is interesting about all of these trespass conversations that we're having is, frankly, our criminal trespass statutes are broad. They apply to everyone. So if we're trying to get to, folks in churches or nightclubs or, those scenarios in which, there is potential imminent danger and you're trying to get someone off of your property, those things make sense. But the reality is our criminal trespass statutes also apply to folks out in the field who are hunting and are fishing. And yes, we have a hunter trespass statute, but hunters and anglers and trappers are subject to both our hunter trespass statute and our criminal trespass statute. So when we are in the field, we are subject to this, even if we are also subject to the hunter trespass statute. So our members justifiably have some concern about the broad reach of doing this. What I will say in the context of the bill more broadly is there are states who have taken what is, in this bill and put it into their statutes. And I think what we're doing is we're putting sort of your common law defense into our criminal trespass statute. But I've spent time over the course of the past week really digging into how other states have done this. And it is a mixed bag as to whether states look at addressing this through trespass statutes or through property defense statutes. Frankly, I'm not sure that this is the right place for to address this. I'm not sure that our criminal trespass law is the right way to do this. We might also look at, our self-defense statutes and actually putting it there and addressing it through 62602. The other piece of this that I think is important to keep in mind is, as other states have done this, there are sideboards, generally speaking, that are put onto use of force in removing someone from your property. So we've talked a little bit about that in our criminal trespass statute, you have to have notice for something to rise to the level of criminal trespass. But what this bill doesn't contemplate is whether the person who is removing someone knows that our criminal trespass statute requires notice. So in other states, as they have implemented this in their laws, have said, before you can do this, you have to notify. And that is part of the statute. It's not just that notification exists in criminal trespass. Before you can remove someone, you physically, as the person, have to notify. So that is written into the statute, and that's not in this bill. There are also provisions in other states where you cannot do this if forcible removal would result in serious bodily injury. So there are other sideboards than other states, frankly, they've contemplated putting removal of trespassers or protection of property into their statutes that just aren't contemplated in this bill. And I think, both from the perspective of hunting and angling in general and being subject to this, I think it's really important to have those sideboards, but also I think just in the context of contemplating using enough, if you're in a scenario where you have to use enough force to get someone off your land, I think it's really important that we get it right the first time in our green books. And I'm not sure that we're quite there with this bill right now. So from our perspective, we would really appreciate sort of not seeing this bill move forward and maybe workshopping it and potentially just taking it out of our criminal trespass statutes altogether. I'm not sure that this is the right way to look at it, given the broader context of trespass that we're living in right now. So with that, I will stand for any questions.
Questions for Ms. King? Okay, good. Thank you again for your testimony. Appreciate it. Anyone else in the room that would like to testify? Welcome. Please introduce yourself.
Good morning. My name is Karen Rogers, and I have been a Geographic Information Systems or GIS professional in the state of Wyoming for over 20 years. I got my start with the Bureau of Land Management office in Pinedale and then worked for the state for 10 years, equally between ETS and the Game and Fish. I now work in the private sector. I'm here today to testify against House Bill 126 because, in my professional opinion, it is ill-advised to pass such a law given the accuracy and quality of the data the public can use to determine whether they are on public or private land. So to me, it's a data thing. I don't have anything against defending public or private land rights, but it's a data thing. So over my career, I have worked with and depended on accurate, authoritative spatial data depicting surface ownership. Sadly, Wyoming does not have one authoritative source of that data that accurately reflects ownership or management by federal agencies or the select few state agencies who also own or manage land. The BLM is the authoritative source when it comes to federal lands. The state agencies with skin in the game are Game and Fish, Office of State Lands and Investment, state parks, and to a much lesser extent, WYDOT. Each of these entities maintain their own version of spatial surface ownership data, with any changes one entity makes not being reflected in any of the others. Of the numerous other state agencies who rely on this data for their business needs, it is anyone's guess when and where they got their data and how out of date it is. I know from my time at Game and Fish that they provide their version of surface ownership data to Onyx Maps, which has been discussed, the company who provides a GPS platform for hunters and outdoor recreationists in general to navigate to public lands. Not due to any fault of their own, the data Game and Fish provides is only coincident with BLM data from the time they acquired it from BLM and started editing it with their own land acquisitions or disposals. It does not reflect any changes on the part of the BLM or other state agencies from that point forward. As I'm sure you all know, we don't go out and recreate just on BLM land or just on a Game and Fish wildlife habitat management area. Our outdoor recreation opportunities do not happen in silos concurrent with the data we use to find those opportunities. The state should focus its attention on coordination efforts to improve the stewardship and maintenance of these data for the benefit of the public and private landowners. For this reason alone, it is irresponsible for the legislature to pass a trespass law with such serious consequences as this, given that the public cannot make accurate and safe decisions given the data available to them. Madam Chair, I will take any questions.
Questions? I actually just have one. Seriously, I thought the data that was provided by the Onyx systems and some of the other GPS systems, I thought it was much more accurate than it is, but it sounds like even if it is somewhat accurate and if it has been updated, that some of the agencies don't talk to each other, there's no uniformity. Is that basically what you're saying?
Madam Chair, that is correct, yes.
Okay. Appreciate that information. Doesn't look like there's any questions from the committee, so thank you for that. Appreciate it. Thanks so much. Anyone else in the room that would like to testify? Okay, I think we have somebody online?
Madam
Go
Chair,
ahead.
we have Mr. Jensen.
Mr. Jensen? Okay. Bring him in.
Madam Chair, we also have Jacob Weiss.
Jacob Weiss? Okay. Is that Mr. Jensen? Go ahead.
Good morning, Madam Chairwoman. Levi Jensen again, Gillette, Wyoming, representing myself as an individual. When I saw this bill, it kind of surprised me that it was necessary. I've always kind of had in the back of my mind that this is something that you could already do. And as it turns out, after listening and watching testimony on the bill, that, yeah, that's true. It's protected by common law. I couldn't help but think of the corner crossing situation as an unintended consequence of this bill. I watched the body cam footage of that corner crossing case down in southern part of the state. It was a tense situation. I worry about a situation that would escalate to, improper use of physical force to remove somebody from that particular situation. And you probably all do know how that situation turned out. They were cited for criminal trespass in that situation, and they were found not guilty of that citation through a trial by jury. So I think that situation applies very perfectly to an unintended consequence of this bill. And I think it's something that really needs to be discussed in committee before this bill goes any further. I don't worry so much about, the intent of the bill, protecting churches and, premises we think of in town, because I think it's done already. I don't think it's that big a deal, but boy, the unintended consequences of moving this bill forward, I think are huge. Figuring out what reasonable force is going to come too late. There's going to be people hurt over something like this, and for that reason, I'm against the bill. I think let's let common law stand, and let's not put this in the green books. I think we should vote this bill down. With that, I'd take any questions.
Questions for Mr. Jensen? Okay, I don't see any. Thank you so much again for your testimony. Appreciate it.
Thank you.
And so is this our next?
Madam Chairman, we have Jacob Weiss.
Okay, go ahead, Mr. Weiss.
Good morning, Madam Chairwoman and members of the committee. My name is Jacob Weiss. Live in Cody, Wyoming, and I'm here today on behalf of myself and other hunters of the great state of Wyoming to oppose this bill. I have a lot of respect for private property rights. I think it's a crucial element of, just the greater livelihood of all of us here in Wyoming. But I have a lot of concerns, especially when it comes to, us hunting and recreating on public lands. Specifically, we've heard a lot of instances, especially with the previous bill that was discussed, where, landowners might think that they are the owner of public land. And, I can, see a lot of instances where, somebody might be out on public land, legally hunting, fishing even, and where they confront a landowner who believes that is their property. Confrontation might arise where the landowner believes that that's their land and wants to use, whatever they determine to be reasonable force to remove this person from this public land that is their legally, ethically, who is doing no harm to the landowner's property. I just, I have a lot of concerns here when it comes to the actual proper ownership of the land, the landowner's awareness, as to where their property starts and ends, as we've heard with other issues with GPS accuracy, or maybe just historical inaccuracy where they think they own a parcel that they actually don't. So with that, again, I would urge you to oppose this bill when it relates to just the greater unawareness of who owns land and the potential risk to law-abiding citizens that might arise from this. And thank you for hearing my testimony. And with that, I'll stand for any questions.
Questions from the committee for Mr. Weiss? I don't see any. Thanks again for your testimony. We appreciate it.
Thank you.
Anyone else online?
Yes, Madam Chairman, we have Jeff Murator.
Murator? Okay, I'll try not to mess that name up. Welcome.
Hello, can you hear me?
Yes, we can. Thank you. Welcome.
Good morning, Madam Chairwoman, members of the committee. My name is Jeff Muratori. I reside in Casper, Wyoming. I am the owner of a small ranch outside of town and several commercial properties and residential properties in Casper. I've been doing this I've been involved in these properties, well, the ranch all my life, and the rentals since 1993. And over the course of that time, I've been involved in probably a dozen trespasses onto my property that in some cases were referred to law enforcement. Without question, every law enforcement officer that I encountered over this time advised that under no circumstances should I or anybody else try to physically remove people. They requested that we take down all the information possible, short of obviously a self-defense issue, but to take down all information possible about the alleged trespasser and to get that information to them as soon as possible. I see this bill as escalating conflicts. This is a day and age that you meet somebody and you don't know who they are. You don't know what they're capable of. And I just feel that there could be many instances here where people will get hurt and possibly killed in situations where someone tries to put their hands on another person to physically remove them. So obviously I'm opposed to this bill. I feel that it just goes a little bit too far. We have self-defense laws already in place. If somebody tries to harm my family or myself, that's a different thing. But this is simply allowing somebody to lay hands on somebody over a misdemeanor. And I'm just worried that people will get hurt.
Thank you, Mr. Muratori. Are there any questions for Jeff? Okay, thank you so much for your testimony. We appreciate it. Anyone else online?
Yes, Madam Chairman, we have Tim Gray online.
Okay, bring him in. More like a labor meeting. Welcome, Mr. Gray.
Good morning, Madam Chairwoman and committee members. It's an honor to be here. Thank you for allowing me the time to talk to you this morning. My name is Tim Gray. I'm a resident of Buffalo, Wyoming. My reason for being here this morning is obviously to address the proposed amendments to Wyoming Statute 6-3-303 criminal trespass. The new language would allow an owner, legal occupant, or their agent to use reasonable, keyword reasonable, physical force to terminate a trespass. Many states already have a statute similar to this proposal. Our border state, for example, Colorado, has a similar statute, CRS 18-1705, and it's been in place in some form since 1963. The law has been tested in court and was seen favorably. You can see People versus Hayward, Colorado 2002, and People versus Toller, Colorado 2000. The law still stands today. I would think if the law had been troublesome in Colorado society, it would have been removed by their legislature. And we've heard a lot of testimony this morning, and it's correct. A Wyoming resident is greatly protected within their home in the defense of self or another. This is evident in the self-defense statute 6-2-602 and is well documented in Wyoming case law. Where a Wyoming owner or occupant or agent is not well protected is a church, school, or business. I see this amendment as a de-escalation tool specifically in our schools, churches, and businesses. I'll give you an example. Consider a teacher or principal attempting to de-escalate a verbally abusive subject in the school. The principal has had police notified and has asked the person to leave, even advised the person that they are trespassing at this point. The person is continuing to be disruptive, disturbing the ongoing business of the school, and still refusing to leave. The principal asks a teacher to assist in the removal of the person from the school building and then locks them out. The principal and teacher should not fear criminal repercussions for this act, such as battery or unlawful touching, which an overzealous prosecutor could do. It's very easy to meet those elements in that crime. For doing what I think anyone in our society would agree was a reasonable, appropriate response to the situation. Objectively, as a parent, I would find those actions reasonable in the protection of a child. You could take this same scenario, can also apply to a church security team, business owner, or a bouncer. I mentioned earlier that I see this as a de-escalation tool. When you're dealing with a verbally disruptive person, you can read their body language, facial expressions, and tone changes, and can usually determine when the situation is deteriorating. What you can't do is read their mind. The person may be getting ready to commit a physical act of violence, or worse, pull a gun and escalate to inflict death or serious bodily injury on innocents. By removing the disruptive person before this happens, we can prevent escalation. We may be able to save lives. I firmly believe that law enforcement should always be involved, but they have to be there to be involved. Law enforcement response times depend on many factors, such as, but not limited to, number of calls for service, location of the nearest available officer, traffic and road conditions, just to name a few. In a city with its own police force, one might expect 911 response time to be around 5 minutes if national averages hold true. However, in our rural areas, churches, schools, and businesses may be looking at a much longer response time. I'm sure most of you have rural areas in your district that law enforcement response time can be 35 minutes or longer, or even longer. A lot can transpire in 35 minutes. A lot can transpire in 5 minutes. One of the most recent church shootings at the West Freeway Church in Texas in 2019 lasted approximately 6 seconds, resulting in 2 parishioners and the suspect killed. Removing a disruptive trespasser using reasonable physical force before they can become violent just makes reasonable sense. It's a reasonable alternative to potentially a physically and or deadly attack. The addition, Section D, clearly limits the use of force to physical force only to remove the trespasser. The second part of the addition, Section E, makes it clear that this does not supersede or add to defense of self or another as already provided by law. I have discussed this proposed amendment with the county attorney, prosecutors, representatives, and others. All would agree with me that any verbiage changes must not add to or supersede Wyoming self-defense jurisprudence. 62602 is a great statute. Our case law is great in self-defense. We don't want to mess that up. All agree the intent here is worthy, as I've heard other people state. It's just about having the verbiage protect Wyoming citizens from unreasonable prosecution, does not create vigilante justice, and does not interfere with established Wyoming self-defense jurisprudence. I truly believe this would be an excellent de-escalation tool added to our law, and I will stand for any questions you may have.
Questions for Mr. Gray? No? No? Thank you so much for your testimony. We appreciate it. Anybody else? That's everyone online?
Madam Chairman, we have one more joining us online. We have Buzz Hettick.
Okay, go ahead. Bring him in.
Can you all hear me?
Yes, we can.
Okay. Yeah, thank you, Madam Chair, members of the committee. I'd just like to also voice my opposition to this. There's just, I believe that there's just too many conflicts that can arise from the hunting and angling standpoint. And we are trying really hard right now as hunters and anglers to work with the private landowners to de-escalate the trespass issues. And I think there is a very real unintended consequence with this bill. And also professionally as well for me, I deal with a lot of private landowners a lot. One of the things we do is we ask for access to private property, usually this time of year. Sometimes that property changes hands, and I've had some pretty tense situations. I don't go out and check the county records every single day in my job. And I can just see a situation, and I've had them already, where, I really think I'm in the right. I have my permission letter. I get out there, an angry landowner comes up, and these situations get really tense. Between that plus all the hunting and fishing I do, I just think this bill is ill-advised at this time. And I think we should probably try to tamp this down. And for that reason, I oppose this bill. And with that, I'll stand for any questions.
Questions from the committee? Thank you very much for your testimony. We appreciate it. Thanks.
Thank you, Madam Chair and committee.
Is that everyone online then? Okay. Well, busy morning this morning. So anything else, Representative Crago, you'd like to finish up with? Bring us home?
I would. Thank you, Chairwoman Schuler. Members of the committee, I feel like we're missing the point a little bit on some of the testimony. We're not trying to change the law. We're not trying to add to. We're just trying to make it clear what the law is so that people can find it. Number one, this only applies if you're quote unquote criminally trespassing, and you have to meet certain standards before you can be criminally trespassing. And one is notice. So before someone can physically go hands-on, they have to ask you politely to leave. I mean, that's the idea. This only comes into play if you refuse to leave after you've been given the opportunity to do so. This will not come into play if someone just comes up to you, grabs you, and throws you in the river, as the good senator referred to. This doesn't provide the defense. What we're doing here is providing a defense for those people who take action when necessary. That's the intent of the bill. And obviously, you heard my testimony, you heard Mr. Gray's testimony. This wasn't about hunting. It's not about that. Obviously, it's in the criminal trespass statutes. It's not in the hunting trespass statutes. Could it still apply? Yes. The difference is, and this is important to go back and remember this, hunting trespass does not require notice for a ticket. Criminal does. So if you're trespass under the hunting statutes, notice doesn't come into play. You as a hunter are supposed to know where you are and if you're on property that doesn't belong to you or is not public. This, you have to have notice. And so I disagree with some of the testimony that the word notice isn't in this particular bill. I actually thought about putting another proviso in there that said after notice, but then it really contradicts the part of the statute above that, because criminal trespass requires notice already. And so it becomes duplicative. I'm not opposed to putting it in there again. I just didn't think we need it because it's already in there. Before you can be found to be a criminal trespasser, you have to have been given notice. Otherwise, the statute doesn't kick in. And so I think it's in there. It's just not in the exact language of this. It's just a couple sentences up within the Green Book. But if that helps, I don't have a problem putting it in there again, but that's sort of where we are. And finally, I think what we're trying to do is give people the security they need to, if they need to take action, they know they can. I mean, that's what we're really talking about here. I'm not trying to give landowners the right to go up and remove people just because they feel like it. I mean, that's why I put the word reasonably in there so many times. The action you take still has to be reasonable. And I would argue that out in the middle of nowhere where the person is not, let's just say they're driving down a 2-track and it's on your private property, you ask them to leave and they don't, what are you going to do at that point? You're going to call law enforcement, really. I mean, at that point, that's the reasonable action you're going to take. You're not going to jerk them out of their car and throw them to the ground. That's not reasonable. And that then goes to the jury, right? I mean, at that point, that person presses charges for assault, battery. The jury gets to decide, was that reasonable for you to jerk me out of my car? The answer is going to be no, right? And so that's really what we're talking about. It's standard that the jury gets to decide. This provides that. With that, Madam Chairman, I have nothing else unless there's additional questions.
Questions? Senator Ellis?
Madam Chair, I'm going to give you a hypothetical, embellishing some details, but a case that I had worked on. You have two adjacent landowners. One of them has a ditch for irrigation purposes on the other landowner's property. As the ditch owner, that person has a right to enter his neighbor's property to maintain the ditch. Say that goes, there's growth, and so they need to bring in some equipment to, clear the ditch. And then all of a sudden that right of way starts expanding. And so, these two landowners don't like each other. They fight, they don't get along. And so you have one landowner who says, you're trespassing, you're on my property. Your right to maintain the ditch has gone way, way too far. And the other guy says, no, I have a right to maintain my ditch, you son of a gun, I can't get water. And then that's, I think, the concern I see is, I understand the public concern, but I also worry about, who's trespassing, what's the right of the ditch owner? I mean, all of that. I do worry a little bit about some of those instances where I know this is in common law, but if it's written in statute, one person says, well, I have a right to, use physical force against you. And the other one says, I have a right to use physical force against you. I have a right to maintain this ditch. So that's where I'm struggling a little bit with codifying it, is, emboldening people, even neighbors who have competing rights to land. So have you thought about those kind of situations?
Representative?
Chairwoman Schuler, Senator Ellis, I actually think the statute will help that situation, and here's why. Right now, people don't know that you and I know, right? As lawyers, we know what the common law is, and it has the reasonable standard in there. Not everybody else knows that. This will say, whatever force you do use has to be reasonable. I mean, that's within the bill. I can tell you, and we've all heard anecdotally about ranchers pulling guns on people and telling them to get the heck off their property, right? Is that reasonable? Probably not. Not if they're just driving through, right? And so this actually says it has to be reasonable. So in your particular scenario, this law is, whether we enact this into law or not, isn't going to change the scenario you gave to me. I mean, that's a civil matter. That's going to end up in the courts sooner or later. Right? People have been fighting over water for hundreds of years. This isn't going to fix that. This isn't going to make it worse. It's not going to change that scenario at all. It's really intended for the other scenarios that I've talked about. I think you've all heard, and this is also anecdotally, right? We hear people worried about, for example, school shooting, right? And they're worried about someone's acting strange, and they're wondering, well, can I grab that person and just throw them out? Can I do it? If I ask them to leave and they don't, and I'm getting nervous, can I grab them? What can I do? People worry about that. It's a thought that goes through people's mind in today's society, is what, everybody's constantly worried about getting sued and going to court. Well, I can't touch that person. I can't do that. What we're trying to do is clear it up so that people can look at the Green Book and say, you know what? If I think something bad's about to happen, I can get these people the heck out of the building. That's the problem we're trying to solve. I understand there's some other stuff out there, but that's why I included the word reasonably or reasonableness within the bill draft as many times as I did to make it clear that we're not allowing for crazy actions by passing the law.
Other questions or comments? Representative Crago? Okay, thank you very much. Okay, with that, committee, what's your pleasure on this bill?
I'll move it.
Okay, it's been moved by Senator Baldwin. Excuse me? Second by Senator Drew. Any potential amendments or other discussion about page 1? Anything there? Okay, page 2. Okay. Senator Baldwin.
Who am I?
Senator Baldwin.
Just a quick discussion. It's interesting in Wyoming how when we see the word trespass, the first thing comes to mind is hunting and fishing. I must not be a typical Wyomingite. When I saw this bill and I saw trespass, the first thing I thought about was my theater. I'm 3 doors down from a bar, and I regularly have to they have too much to drink. They come to my theater, I say, get the heck out. And I've never grabbed anybody and thrown them out. Nobody goes from my theater to the bar having had too much popcorn, I might add. But that's the first thing that came to my mind, and all of the landowner and the hunting and fishing stuff came secondary. My belief, and I'm not an attorney, but is that that's all pretty well addressed in the hunting, fishing, trespassing, and I think that this addresses something else. So those are the first thoughts that came to my mind. And I would add, and I think I could do this at committee, I can actually use proper names. It's legal here. I would recommend that everybody watch the show Fear Thy Neighbor, because it addresses this topic very clearly of neighbors, be they local in the city, be they out in the country, things that go south. It starts out very well and it turns into a mess. And it turns into much bigger than a mess, but I think it addresses all these things, specifically what this bill points at. So I'm going to be an eye on them because I think it addresses something outside of the hunting and fishing trespass. And I think that's well addressed in the statutes already. So just thought I'd add that editorial.
Thank you for your comments. Anyone else? Comments? Senator Grew?
Thank you, Mr. Chairman, or Madam Chairman. I'm on and against, and I understand the good senator and where his thoughts immediately went. Because it's TRW, I necessarily kind of went the other way first, but the more I looked at it, the more I thought about all the ramifications, and actually it led me to the opposite answer. It's the word reasonable. When I hear the good head of the stock growers and the bringer of the bill talk about reasonable, I know them. I know what's reasonable in their mind. I've also seen in situations out in the real world, people are very unreasonable. And that's what bothers me about this bill, is what's reasonable to some is far less reasonable to me. And that's my fear about this bill, about unreasonable people on both sides. In the more urbanized applications, I think law enforcement, that's what law enforcement's there for. I think that is the way it goes. Then if it's too fast, happening too fast for that, yes, there are self-defense statutes. We have a plethora, many of which I didn't vote for, but they're there, and they're the law of the state as far as how people can deal with situations where their life, safety, their families, their own personal well-being is at stake. There are ways they can do that. Those avenues exist. I'm afraid that this piece of legislation opens some things up and will have unintended consequences, as some people have said, that I don't think we're prepared for. I don't think that I know it's a different society today, but I would like to think, and maybe it's just because I'm a little Pollyanna type, but I don't think it's that much different. So I'm on and against.
Senator Ellis?
Thank you, Madam Chair. I think the analogy I just heard from my colleague here is a little inaccurate in that when you have a business, it's open to the public. I mean, that's the contemplation of it, is that you want customers. So there are different duties, and the criminal trespass doesn't really fit in that. I don't think that would be applicable, because you can't say, well, you're welcome, we want you to spend money here. Oh, wait, you're criminally trespassing. Now you're on notice, you have to leave. That never seems to apply, but I just wanted to kind of make that clarification. And then, just my situation that I described, two landowners who really dislike each other, both think they have the private property right. I see them fighting and having assault charges, and having our courts have to resolve, who was in the right on the assault, but it's all tied to whether or not the trespass was actually illegal or not. They both claim they have a legal right to be there. So, in that particular instance, they're going to duke that out in court. They're going to have civil fines. They're going to look at all of those issues, but that all happens without the fist fight. So I'd agree that there's a remedy in the civil court. I just don't want to add a criminal case to it with two landowners who both think they're in the right, claiming this defense. So I am a little concerned about it. I'm not saying I could never get there, but today I'm not comfortable.
Anything else? Senator Jones? Okay. In that case, question on the bill. Roll call vote, please.
Thank you, Madam Chair. House Bill 126, Senator Baldwin.
Aye.
Senator Ellis.
No.
Senator Guru.
No.
Senator Jones.
No.
Chairman Schuler.
Aye.
We have 3 ayes and 2 noes.
3 ayes, was it 3 noes and 2 ayes?
Yeah, I think it was the other way.
Aldwin, Guru is a no.
Okay,
We have 2 ayes and 3 noes.
okay. And I thank you for the bill. I also had some issues with this. I wasn't sure. Again, I thought in terms of the trespass more than I did the personal part of it. And, but I always, kind of lean towards, well, let's take it up on the floor and take a listen and see if there's something else up there that we could hear. But maybe we'll just take a look at this maybe later on and might be something for an interim study. And so I appreciate the bringer of the bill, and thanks for all the testimony today from everyone. Appreciate it. This bill has failed. And with that, unless there's any other comments, we will adjourn.
Sorry, Jerry.